Good morning. This is Derek Grimmel from the Montana VA, and this is our didactic on psychology and the law. So, why are we even talking about this topic? Well, law is a scary thing to most psychologists. I've had many colleagues who have gone to training seminars to learn how to comply with law or ethics or not get sued. And they would come back discouraged and convinced there was no way to avoid all the dangers. They might as well just surrender their license and go do something else. The reality is that people tend to project memories of angry parents onto authority figures, especially unfamiliar authority figures. They assume that anything that they do that might possibly justify punishment will lead to a degree of punishment somewhere between Joseph Stalin and a cave bear. And given that psychologists are mostly not attorneys and try to have minimal interactions with the courts, there is a tendency for us to project our own ideas of arbitrary cruelty onto the legal system. It's easy to identify when projection is going on. Just look for the attribution of contradictory qualities to the same object. So it's easy to find people who at one and the same time view the law as a bunch of hapless Keystone cops who are unable to protect their own donuts, and demonic oppressors looking for any opportunity to rip us apart and feed our bodies to alligators. Both of those can't be true at the same times, folks. When you see opposing qualities put onto the same object, there's likely projection going on. The legal system is not populated by monsters or by klutzes. It's filled with reasonable people who are trying to remain reasonable when people involved in disputes have become unreasonable. The best way for us to withdraw our negative projections and get back to comfortable reality is education. Learn more about the law. Projection always works best when it goes onto a blank screen. If you try to project something onto a wall that has several pictures already really hanging there, the projection is a whole lot less convincing. So the best way to get out of what we project onto the law and back to a sense of reality is to learn about the law. So I encourage not only every psychologist, but every citizen to learn more about the law so that you understand where the boundaries are, what the right and wrong things are to do, and you can sleep better at night. So, what is the law anyway? Well, in our system, you can do a lot worse than to consult with Oliver Wendell Holmes Jr. He was a combat veteran of the Civil War who served 30 years on the U.S. Supreme Court, becoming arguably the most distinguished justice of the 20th century, as well as the owner of one of its most dazzling mustaches. And Holmes used to say that law is fundamentally a statement of society's willingness to use force. What the law does is to use the power of a community against one of its own members who is judged to have acted wrongly. So a legislature may write a ban, a jury will render a verdict, a judge will pronounce sentence, correctional and peace officers will enforce the sentence, an employer will garnish wages, and everyone else will stand back and do nothing more than comment, all because the law says so. The law defines the object of attack as a person who has done what society will use force against. And to Holmes, a right, a civil right, was nothing more than something that people are willing to fight for. So when we identify rights, what we're doing is identifying those boundaries beyond which society will not go against its own citizens so as to ensure that there isn't a rebellion. So that is a good way of thinking about the law, and we can ask the question, what things could we do that will cause society to be willing to use force against us? And there aren't that many things. It's actually fairly easy to get on top of that question and be a lot more comfortable in your clinical practice. So part one of this talk is an orientation to the law. Part two covers legally safe psychological practice. Part three covers interactions between clinicians and the legal system. And part four covers work done in the forensic arena. So first off, it's important to know that there are three different bodies of law. Statutes are written by the legislature, regulations are written by the executive, and common law or case law is written by the judiciary. Our founders divided the power of the king up into three different branches of government and then into a federal and a state level because that was their scheme for ensuring that governmental power would not become arbitrary and capricious and tyrannize the people. So whenever you hear someone complaining about judicial activism, what they're really saying is, I want us to go from three branches of government down to just two or maybe even just one. Whoever they aren't a friend of liberty. The power got divided up for a reason. You put three scorpions into a bottle together so they'll sting each other and not you. So where do you find these things? Well, federal statutes are in the United States Code, and they're referenced like that, 42 U.S.C. 1395. The first number is a title, and the second number is a section. You can find the U.S. Code at gpo.gov, the Government Publishing Office, or at uscode.house.gov. Regulations are in the Code of Federal Regulations, and those are referenced like 45 CFR 164. The first number is a title, but here the second number is a part. 45 CFR is better known as HIPAA, and the title numbers do not match up between statutes and regulations at the federal level, and usually not at the state level. Scorpions, bottle, sting each other. Each state has its own naming convention, but if you search for the state name and statutes or the state name and code or administrative code, you should be able to find your state's laws pretty easily. They're actually organized with some degree of sensibility. They want to be able to find their own laws. So whatever state you're practicing in, get familiar with your own state statutes. Case law, written by courts, is written up like this. Service v. Dulles, 235 Second Federal Reporter, and then Service v. Dulles, 354 U.S. 363, 77 Supreme Court 1152. In all of these, the first number is a volume number, the second number is a page number within that volume, and in between you have the series of books that they're talking about. So the F2D is the second series of federal reporters. F.3D is the third series of federal reporters. U.S., S, Supreme Court. States typically have their own state reporters, such as the Montana, or they'll be in a regional reporter. P2D is the second Pacific reporter for states in the Pacific region. But always the first is the volume and the second is a page number. Interestingly enough, the government did not start publishing their cases. Rather, in the 19th century, a company called West Publishing began gathering up cases from the different courts and publishing these series of reporters. And the legal profession said, oh, that works for us. So they just started using West Publishing's reporter series. Nowadays, you don't need those long shelves of books. You need Google Scholar. So you can go out to Google Scholar and click on case law, type in whatever term you want to research, and you will get a sorted series of cases, sorted using Google's magic for what cases are the most important given your search term. You can click on the title of the case, like Pate v. Robinson, and you'll pull up the actual case, which starts with a recitation of the facts of the case and then goes through how this court analyzed the law and applied it to the facts of the case. Down below you have cited by 4,125. Those are all the cases that have cited Pate v. Robinson. And again, those, if you click on that, you'll get a list of cases citing the STEM case that are sorted in order of importance within the scheme of legal citations. I encourage everybody to go out and read case law from time to time because it's the best entertainment you can buy. When they say you can't make this stuff up, they mean it. In the fact patterns, you will read things that are hilarious. You'll read things that are outrageous. You'll read things that are very sad. You'll read things that came into a court from the extremes of the society. It's almost an anthropologist's dream. If you wanted a quick introduction to our actual society, I don't know a better place to go than to go out and read case law. So in our overview, law is about duties. I was presenting one time when a fellow in an exasperated tone of voice asked, "Is there some place we can go to learn what all our duties are?" Yes, you go to the law. Law defines duties, and a duty is that thing that if you breach it, society is willing to use force against you. Our goal is to avoid breaching any of our duties. So you can think of constitutional law as defining the duties of the state to the people. Mostly, the government has negative duties. Duties to avoid doing certain things, like don't tamper with religion or don't do search and seizure without probable cause and a warrant. There are very few positive duties, things that the government owes it to the people to do. Criminal law defines the duties of the people to the state. So these are the actions that if you do them, the state will come after you whether there's a plaintiff or not. The state will act on its own behalf. Civil law defines the duties of the people to each other. In those cases, the state will not pursue a wrongdoer, but the aggrieved party can go to court and say, I have a beef with another citizen who I think did me wrong, and they're going to try to convince the court to step in and use society's power against the other person. And they either win or they don't. Civil law offenses are called torts. Three groups of civil law offenses are intentional torts, negligence, and strict scrutiny, strict liability. So intentional torts, negligence, and strict liability, those are different kinds of civil offenses with different burdens of proof and lines drawn in the sand. One of the things that's important for us to understand in mental health is that law is a highly category-driven enterprise. So we don't take our categories all that seriously. I don't know a lot of people who would bet on the difference between bipolar with psychotic features versus schizoaffective disorder. The boundaries between our categories tend to be somewhat fuzzy, more so for some categories, less so for others, but we accept that diagnoses can be wrong. By contrast, a lot of the law is about defining which categories this fact pattern falls into. And those categories are rigid. Law thrives on bright line distinctions. So by the time litigation reaches the stage where the categories have been defined, usually all of the attorneys in the room know how the case is going to come out, and that's usually when they will settle the case. So what do we need to do in order to practice safely? Well, here's a set of things. It's not arbitrary or capricious. Law spells out our duties. We have two duties to our patients that are defined in law. Develop and keep updated our level of expertise and work diligently to prevent suicide. We have 4 duties to our patients and to the state. Protect and maintain patient information. Obtain informed consent prior to offering any services. Obey our jurisdiction's laws about duty to warn. And exercise due diligence during supervision of unlicensed practitioners. And finally, we owe 2 duties to the state. Learn and follow the state's code of conduct for psychologists, and obey our jurisdiction's laws about mandatory reporting. Those are the areas that the law has carved out in which it defines duties. Everything beyond that, we get to practice as we see fit. So we're going to take each of these in turn. So our level of clinical expertise, the state expects us to engage in lifelong learning to keep our methods in touch with best practice. You will meet psychologists who do not do this. Don't be one of them. Anything where we have not had legally defensible preparation is outside of our scope of practice, and we should either get supervision, learn how to do it, or refer. Legally defensible preparation means that we can show in front of a tribunal how we learned this method and how we conformed our practice to that method. So for example, if there were an allegation that I don't know a diddly squat about how to do acceptance and commitment therapy, and it came before a tribunal, I could show the tribunal my several different CEU certificates, and I could show them the 3 books that I rely on, and I could show them the credentials of the authors of those books, and then in my notes I could show how I was using those materials and I was using them correctly. And that's the end of the complaint. I have legally defensible preparation in that area, which I can demonstrate to a tribunal. The duty that we all owe to our patients is to conform our practice to the standard of care that a reasonable practitioner in that area would apply. A reasonable practitioner does not mean average. It does not mean typical. It does not mean minimum. A reasonable practitioner is what a reasonable psychologist would choose from among the available options after inspecting the research literature. So reasonable means based in reason and evidence. Brief reminder here, the law is not staffed by monsters and it's not staffed by klutzes. Okay, so a tribunal is not waiting out there with steam coming out of its nostrils looking for an opportunity to kill you. What they're looking for is, did you act responsibly in choosing the methods that you employ and in applying them in particular cases? They're not looking for perfection. They are looking for, you were reasonable, you gave due effort, you made a good faith effort to choose good methods. When you diagnosed, you did reasonable things that can be explained to a tribunal. If you've done all those things, you're on safe ground. If you're not doing those things, then you should begin. So torts and psychological practice, well, malpractice is the one people are most worried about. Malpractice is a tort of negligence. And to prove negligence, there are 4 things you typically have to prove. Did you owe a duty to the injured party? Did you breach that duty? Did this breach cause an injury? And did this injury lead to damages which the law is willing to compensate? And in some circumstances, a 5th factor, foreseeability, is applied. Damage that could not reasonably be foreseen may not be compensated. So for example, if I invite you over to my house as someone I've invited into my house, not a trespasser, I have a duty under law to warn you of any known unsafe conditions at my house. So if there's a set of uneven steps, which I know about, and I don't warn you to watch out for that second step, and you trip and break your leg, I had a duty to warn you of any known unsafe conditions. I breached that duty. I didn't warn you. That led directly to your injury, and a broken bone is the kind of injury that the courts will recognize as damages and will compensate. If, by contrast, I invite you to my art exhibition, and one of my paintings is an insulting portrait of your grandmother, you react with shock and I laugh at you in front of others. Now, did I owe you a duty? No, I'm a jerk. Nobody owes anyone a duty not to be jerk, or everybody would be in court every day. So with no duty, there is no breach. Did my conduct injure you? Yes, it hurt your feelings. Will the court award damages for that kind of hurt feelings? No. As the law says routinely, it's not a perfect world, and not every harm will be compensated. So toughen up, Buttercup. So let's take a quick example that illustrates one of the problems that makes it important for you to educate yourself. Our media like to sensationalize the law, and particularly for some reason they seem to like to discredit the law. So you may remember that in about 2005, an administrative law judge sued a dry cleaner for $65 million for losing a pair of his pants. And this is America. Anybody can sue anybody for anything at any time. Take your dispute to court. It doesn't mean you're going to get anywhere. But I know that case got a lot of publicity early on. But here's how that actually played out. The fact pattern was that he went to a business named Custom Cleaners, which lost a pair of his suit pants. The owners disagreed that they had lost, but they eventually offered to settle. The business happened to have a satisfaction guaranteed sign on their wall. So this administrative law judge argued that it was in breach of promise so long as he personally remained unsatisfied. So the benefit to him was that his personal feelings of satisfaction were the benchmark, and so he alone would determine whether that business had met those obligations. As one website has pointed out, the drawback of this argument is that it's complete legal BS. But this administrative law judge proved to be impossible to convince of this fact. So when the business offered to settle, he would move the goalposts, saying he still remained unsatisfied. He kept escalating his demands and offered a theory under the District of Columbia Consumer Protection Statute, so that by April 2007, he was demanding over $65 million. The case went to trial and he lost. He appealed and he lost. He sought en banc review and he lost. And that was the end of the litigation against the dry cleaners. They were in the clear. But he wasn't done. He lost his administrative law judge job because some people suspected this all showed poor judgment about the law. So he sued for wrongful termination. He lost. He appealed and he lost. Turns out that if you keep making frivolous arguments in court, the Bar Association may get involved. So the Office of Disciplinary Counsel in 2015, 10 years after the loss of the pants, filed ethics charges against him, which he contested on the ground that he was right. He lost. He appealed. In 2020, he lost again on appeals. Okay, so you cannot prevent someone from being a jerk. But the law is not staffed by monsters, and the law is not staffed by klutzes. It's staffed by reasonable people who, faced with a jerk, will act reasonably. That's how the law actually works. So, talking about our level of expertise, every state has their own rules regarding what kind of training do you need to get and how often do you need to get it. And nowadays, states tend to be defining areas where you need to get CEU credits every so often. For example, Iowa says that you need to get abuse reporting retraining every 5 years, last time I checked. So part of our duty is to find and read our state's regulations regarding continuing education and comply with them. They will almost always be referenced on the website of the State Board of Psychology Examiners. Be sure you're going to the actual board website, not some data skimming site. So you can just Google state name, Board Psychology Examiners, and it will be one of the first 3 references. If they don't have a link to all the regulations right there on their homepage, then you'll find the regulations noted in whatever materials they have for people who want to get licensed in that state. Now, a while back, I asked a suicide coordinator what he thought were the best resources for CEUs on suicide. He asked me, how many hours do you need? I recommend you not think that way. My response was, it's not about needing a certain number of hours. It's about keeping my knowledge base up to date. What are the best trainings? Everybody I know who's any good at this field goes well over the minimum number of hours that the law requires. I typically double them, as well as doing additional training that doesn't even yield CEU certificates. One of my original supervisors routinely doubled the 2-year requirement in every year. That's what a responsible practitioner does. Okay, one of the areas where we need to maintain our expertise is the assessment of suicide risk and the prevention of it. In doing that, we want to look for tools and training that are credible. And here are some examples. I'm not saying that these are the best in the field. I don't know that I know what is best in the field. But these are examples of things that a reasonable practitioner would look up and might conclude, this is good stuff for how to prevent suicide. In general, the trend of the field is toward collaborative, ongoing suicide risk assessment, starting off by saying, by creating an environment in which we presume and model talking about suicide as a natural thing to do during mental health care. The reality is that we're looking for a low base rate event, which means that risk factors are of limited value in assessing and managing patients' suicidal thoughts and actions. That's why Job's produced this book. It's better to create a climate in which talking about thoughts of suicide feels safe and is normed as natural. So when I say it's a low base rate event, here's what I mean. The Wolverines, Michigan Wolverine football stadium seats 110,000 people. So if you've ever seen the blimp shot, we've got 110,000 people. Let's fill that with a representative sample of American adults. If we did that, so we've got a perfectly representative sample of American adults sitting in that football stadium, just over 20,000 of them will have some diagnosable mental disorder at that time. 7,300 will be in a major depressive episode. 3,100 will be in a mood episode as part of bipolar disorder at some time in the next 12 months. 1,500 of them will be diagnosable with borderline personality disorder. 660 of them will be schizophrenic. 4,600 of them will have a mental illness serious enough to impair them in at least one major life area. And yet, in the next 12 months, only 15 will complete suicide. So we can't just talk about risk factors. Risk factors are hundreds of times more prevalent than our actual suicides. That's why we need to create a climate in which it's safe and natural to talk about suicide risk. And as an illustration of that, one way of doing that is to de-escalate our own response and to start talking about suicide ourselves in a natural way. So for example, we might say to a patient, if you had to rate your mood from 0 to 10, where 0 means it's totally hopeless and I'm just going to kill myself, and 10 is I'm feeling just great today, where would you be today? Based on research I read a long time ago, when I asked people about suicidal ideation, I also asked them about specific means, like have you thought of jumping, have you thought of cutting, have you held a gun and thought about using it, things like that. The current evidence is that this does not make suicide more likely, but it does shake out more past attempts. So I have had people deny any past history of suicide attempts until I specifically asked them about tying something around their necks. And then they said, oh yeah, there was that time I tied a belt around my neck, but then I didn't go through with it. Okay, so that's the idea here. If you want to look for a place to update your knowledge base, there is an organization called the American Association of Suicidology, and that's a good place to go to start looking for resources. Okay, now we move into areas where we have a duty to both the patient and the state. Patient record keeping. The duty that we owe to our patients is to ensure that continuity of care can be maintained. So we keep records so that if we get hit by a bus or anything else happens, or if the patient decides to fire us and go somewhere else, the next provider can get access to what we did and continue care. That's a reasonable expectation, and I can see why society would want to use force against us if we don't do that. The duty that we owe to the state is to preserve evidence against the possibility of future hearings. Certain people will file board complaints or will file lawsuits, and incidentally, the number one way that happens is if you piss them off. People don't sue because they're injured, they sue because they're insulted. So the state asks us to preserve records for use in later court actions or before administrative boards. The reality is that in our system, there are penalties for not preserving information. So for example, I saw one case of a person who slipped and fell and injured themselves in a Walmart and knew enough to do the right thing and go out and get an attorney to send a letter to the Walmart saying, preserve your tapes of what was going on inside your store that day on your security cameras. Because the person was alleging that they slipped and fell on a wet floor and there was no sign up saying caution, wet floor. Well, when the case came before the court, Walmart had erased the tapes. In that kind of circumstance, a judge is entitled to tell a jury that they are entitled to assume that the destroyed evidence worked against the person who destroyed it. So in that case, $500,000 was awarded to the plaintiff solely because Walmart destroyed the evidence. Don't destroy evidence. Maintain your records. Record retention period is defined in state law. Every state has their own definitions, and they may have different definitions based on whether it's a pediatric or an adult case. Records retention periods are not usually terminated by patient death. You still hang on to the records for the required period. So how long does HIPAA require us to keep records? How long does Medicare require us to keep records? Well, if we're talking about case notes, they don't have any requirements. State law governs how long you keep patient health care records. HIPAA does require us to hold on to our HIPAA compliance documents, like our internal instruction manuals, for a period of 6 years after they've been revised. So if you're running your own private practice and you hire staff and you develop a training manual for HIPAA, and then you revise your training manual, you have to retain the old one for 6 years. But HIPAA does not require us to keep patient records for any length of time. Similarly, Medicare does not tell us to keep patient records for any length of time. They tell us to keep our Medicare billing records for 5 years. Patient record retention period is defined by state law only in this country. So how long should you keep your records? Well, you can read your state law, or you can do what I do, which is keep everything forever on a FIPS 140-2 Level 3 validated drive. FIPS is the Federal Information Protection Service. Did you know that existed? Neither did I till I learned about this stuff. They define what data storage is intrinsically regarded as HIPAA compliant. And what that means is that if you have your records on a drive that meets this standard and then you lose the drive, you don't have to notify anybody because it's the assumption of the government that those data cannot be accessed. So currently, 3 manufacturers make drives that comply with this standard: Apricorn, Kingston, and iStorage. And you can get all of them off Amazon. It would be a good idea to get, I have 3 of them, so that I always have one that's the working drive and then 2 backups. And I also use a software solution, which is SecureKey. In that case, I contacted the manufacturer of the software package and asked them to advise me which FIPS 140-2 certificate did they have, and they gave me 4 numbers. They referenced the Microsoft certificates, and as it happens, Microsoft has complied with FIPS 140-2 in Windows, and then they license that out to software manufacturers who don't have to develop their own compliant software. They can just use Microsoft's tools. So SecureKey is one software package that complies with HIPAA. So I both encrypt it using software and store it on an encrypted drive. I think I'm pretty safe. So when we talk about our duty to maintain records, we also need to talk about maintaining patient privacy. There are 3 levels of legal protection wrapped around our patient's information. Those are confidentiality, privilege, and privacy, and we should talk about them separately. Confidentiality historically has been part of the treatment contract. When people come to a physician or anybody else, the provider agrees as part of the treatment contract to keep the data secret. However, many states have written laws protecting patients' records, and they've done this. They've defined one thing that has to be in our treatment contract for the convenience of the courts. One of the things we all need to get used to is that in every dispute, there are actually 3 parties. There's the plaintiff, the defendant, and the court itself, which has interests. Courts have an interest in not having their time wasted, not having litigation multiplied endlessly, and not having people be sloppy and careless in their dealings with each other and then asking the court to sort it out later. So it's often true that when an area gets litigated several times, the state will step in and write a law on how this part of a contract is going to be handled in the future. And if you don't do that, then society will use its power against you. So states have written laws regarding patient confidentiality so that if something comes to court, there's no ambiguity about who is in the wrong. Privilege is an exception to the general law that says that all citizens who have information relevant to a lawsuit have to come to court and give their evidence. There are certain kinds of information that the state has taken out of the courts. So if the information comes into existence in a protected relationship, then a person can claim privilege. An example of that is spousal privilege. The state has for centuries understood that asking spouses to testify against each other and punishing them if they don't really harms the whole society. And so courts agree not to ask for that kind of information? Well, there is a psychotherapy patient privilege in most jurisdictions. In different jurisdictions, privilege may be governed by statute, regulation, or case law. At the federal level, it's been case law. Statutes will usually be found either in your state's rules of evidence or the rules of civil procedure. So look up privilege in those two places. If you get a PDF, scan for the word privilege, and it will tell you how it's defined in your state. The degree of privilege that will apply can vary based on the legal category the case is in. So, for example, typically the highest degree of privilege shows up in civil cases. And then there's a lesser degree of privilege in a criminal case. And in some states, if the allegation is of child abuse, there is no privilege. Psychotherapy records come into court because of the overwhelming importance of getting it right on allegations of child abuse. So again, category, which category the case is in determines how much privilege there is. Privilege can only be waived by the holder of the privilege, who in our case would be the patient. So if you're subpoenaed to testify in a case, what you do about privilege is you get called to the witness stand, you take the oath, you sit down, you give your credentials, and then somebody asks you about, did you see this patient? And then you say, at this point, I'm going to request the privilege or invoke the privilege on behalf of my patient records, and then turn and look expectantly at the judge. And if the judge says that the privilege is upheld, you don't have to testify. If the judge instructs you to answer the question, go ahead and answer the question. You can never be held liable for obeying an order from a judge. And lastly, privacy is actually a constitutional right. HIPAA is a civil rights regulation. It defines privacy as a civil right of our patients, and violations of HIPAA are civil rights violations. They're not torts. So if someone is litigating over patient record violation under HIPAA, it's not a malpractice allegation. It's actually a civil rights suit, which will be investigated and prosecuted by the Office of Civil Rights of the Department of Justice. So privacy is an entirely separate issue. And when someone asserts that I have a right to privacy to my psychotherapy records, that will oftentimes go straight up to the federal level and get litigated there, because constitutional rights are intrinsically federal questions. And again, what you do is you raise the issue on behalf of your patient, and you obey the orders of a judge unless you have previously decided this is the hill you want to die on. We'll talk more about responding to subpoenas and requests for testimony later. Okay, HIPAA is found in 45 CFR 164, starting at subpart 300. You should know that as of April 2021, when I'm recording this, HIPAA is going through its first revision process in about a decade. The revisions are currently in the public comment phase. So watch for changes, and you may want to get on this and participate in the public comment phase. HIPAA has typically been a pretty responsive set of regulations. Okay, another duty that we owe both to our patients and to the state is to obtain informed consent prior to treatment. Courts have ruled for decades that when people contract with us to engage in treatment, it's handled under ordinary contract law. It's just another contract. And if the services get litigated, the courts will look upon it like they would a contract to paint your car or to mow your lawn. What this means is that we need to disclose up front anything that a reasonable person would want to know, and that consent must be free and uncoerced. Remember that a reasonable person doesn't mean a typical person, and it doesn't mean me. It means anything that a person using reason would want to know before they exercise their reason. So we don't have to tell them everything, every pro and con, but we do need to disclose the things that a thinking person making a thoughtful choice would want to include in their decision. Consent being free and uncoerced means that we offer no inducements or any potential risks just to try to sway the choice. Now, one of the things that I emphasize is that informed consent is not something that you want to get through so you can get to the good stuff. The informed consent process is your first opportunity to begin building rapport. It's a time when you can show people that you are concerned for them and considerate by how you respect their right to make a decision. So when I was examining prison inmates, I twice had people come to me and say, you know, when I came here, I planned to refuse to have anything to do with you. But after this discussion of my rights and how carefully you've looked out for them, I've changed my mind. I want to talk to you. That's a sign that you're doing the informed consent process right, when your consent process actually makes people trust you. So if people would come to me and my conclusion was that they were dealing with post-traumatic stress disorder, part of the informed consent process would be to say there are 4 different outpatient treatments that have been tested and are known to work, and then describe each of the 4 and the pros and cons of each, the basics of the approach, and then give them my opinion based on the kind of thing that they were dealing with, which of those 4 would be better and worse choices, and then invite them to ask any further questions. And then if they wanted to do a treatment that I did, I would do it with them. If they wanted to do a treatment that I didn't do, I would refer them to someone who did that treatment. That's an example of how you do it. Now, it is true that not everyone is competent to consent to treatment, or along the same lines, to refuse to consent to treatment. The courts are very, very clear that informed consent means nothing unless a person is free to reject a treatment that the treatment provider thinks they need. So it's assumed under law that competent people can disagree with a treatment provider and say, I don't want to go through this. The legal criteria for evaluating capacity to consent vary by state. So that's one of the things to look up in the state where you practice. A general framework looks something like this. First, does the person express an awareness that they have a choice that needs to be made? Second, is the person able to express awareness of the alternatives? Third, can the person describe the pros and cons of their alternatives? Fourth, is the patient able to express a preference? And finally, is their preference based on a rational factor rather than on something arbitrary or capricious? Again, states will differ as to where the line is, indicating a lack of capacity. In general, if the person passes all of those, then the choice is competent. And if they fail all of those, the choice is not competent. Beyond that, you need to check on your own state's criteria. You will sometimes be called upon to assess capacity because medical people don't approve of the person's free choice. As long as the choice is competent, patients have a right to decide in the direction they prefer. This is part of a decades-long shift in the law from paternalism toward personal autonomy. We're moving into the realm of personal autonomy, which means professionals do not substitute their judgment. They help their patients to make the choices that the patients want to make. Okay, let's talk about everybody's least favorite topic, duty to warn or duty to protect. The stem case was Tarasov v. Board of Regents, but currently the operative and most often cited precedent is Thompson v. Alameda County, and I have the 3 different series of reporters here in which the case is published. So if you want to find your state's laws regarding the duty to warn or the duty to protect, the way you do it is go to Google Scholar and choose case law. Then type in as a search term Tarasov v. Regents. And when you find Tarasov v. Board of Regents, click on the link underneath it that says cited by however many cases. That'll bring up a list of every case that cites Tarasov. Now click on the box under the header that says search within citing cases. Then on the left, click on choose courts, and on the screen that pops up, uncheck everything except your state. And now you'll get a list of all of your state's cases that reference Tarasov v. Regents, or you can do it with Thompson v. Alameda. The cases that come up will point you to your state's laws regarding the duty to warn and duty to protect. You should also be able to find them off the Board of Psychology Examiners websites. Most states have some kind of laws in place on this topic now in order to clarify for everybody what the rules are. Typically, the rules are that our current patient has to make a prior threat aimed at a specific identifiable other person. But rules in jurisdictions vary. In Montana, the prior threat has to be by a specific means. So if a person says, I'm gonna kill my brother-in-law, that does not trigger a duty to warn. But if he says, I got a gun at home, I'm gonna go get it and shoot my brother-in-law, now the duty to warn exists. And the law will typically specify what you need to do in order to fulfill that duty. It's important to clarify that our duty to warn is a duty we owe to the intended victim, not to our patient, the person who's going to do the harm. So there was an Iowa case in which someone went out and, after making a threat toward an ex-spouse, I believe, went out and committed murder and then sued her psychiatrist for not warning the victim and thereby preventing her from committing murder and getting a life sentence. After the Supreme Court got done laughing, they threw that lawsuit out saying, your psychiatrist didn't owe you the duty to warn. Your psychiatrist had a duty to the intended victim. You, the patient who then went out and killed, you don't have the right to sue anybody. In general, the rule is nobody has a duty to control the behavior of a third party when it comes to breaking the law. All we have is a duty to warn an identifiable person according to our state's requirements. Okay, finally, supervision. It's important to understand that more than half of all states impose a strict liability standard on psychology supervisors. Remember that the 3 kinds of civil wrongs were intentional torts, negligence, and strict liability. Strict liability means you're engaged in an activity that your community regards as especially hazardous, and therefore you will be held accountable for any harm that results no matter what. That's strict liability. Psychology supervisors in the majority of states are under a strict liability standard. So supervision carries a lot of risks with it. Do not sign on to be somebody's supervisor lightly. Here is one resource you can look to understand what due diligence is with respect to psychology supervision, and look for articles that cite this article as time continues to pass. And this is another one to check out before you take on a supervisory role. Last 2 points on legally safe practice. Code of conduct. Duty you owe to the state is to find the code of conduct for your state and comply with it. Do not assume that it's the APA ethics code. South Dakota and Kansas have both written their own code of conduct in their administrative regulations. So look those up, read them, and follow them. Mandatory reporting of abuse and neglect. Again, locate and follow your state's rules regarding reporting of abuse and neglect of children and of vulnerable adults. It can sometimes be a pain to look this stuff up when you're under the gun because there are time limits for when you are supposed to report. So do this in advance, and especially if you're working at the federal level in the VA. These are state rules. So you need to look up the state in which your VA is practicing, because that's the state rule that the federal courts will impose upon the VA in the case of a dispute. If you're working within the VA, also make sure to contact your release of information officer and talk to your supervisor to make sure that you're complying with VA federal regulations with any report. When you look this stuff up, pay attention to who's a mandatory reporter and who's a permissive reporter. States differ on this. And here is another article that you can look up to learn more about making maltreatment reports. So the summary is, when you're just a practitioner, as long as you maintain records of your treatment, keep them secure, disclose them with a properly executed release, and otherwise comply to laws regarding confidentiality and privacy. And if you make your mandatory reports regarding abuse, neglect, and dangerousness according to your jurisdiction's laws, and if you read your code of conduct and stick to it, manage suicide risk up to date with the standards of your field, and are diligent in supervision and in keeping your practice up to date, you have nothing to fear from the law. The law will pat you on the back and take your side. Okay, let's talk about an issue that tends to cause a lot of stress, which is dealing with a subpoena. We're moving into psychology interacting with the legal system. An overarching thing to understand is that anytime you're interacting with an attorney who is not your attorney, they can legally screw you to the wall in the service of their client's interests. Neither trust nor believe anything they tell you. You get your own lawyer. So when you get a subpoena, subpoenas are requests to give information to an attorney. A subpoena duces tecum is either a request for your records or that you come to court and provide both your records and your personal testimony. It is never safe to ignore a subpoena. Attorneys are officers of the court. They are king's agents. They have the power to demand information to be used in litigation. And if you ignore a subpoena, they can go to the judge and say, Your Honor, I didn't get a response to this, and the court will hold you in contempt. Contempt of court is no fun. Don't do that. Every subpoena has to be responded to. It's part of the price we pay for civilization. So discuss the issue of subpoenas during your informed consent process. It's a gap in privacy right next to duty to warn and the duty to report abuse. Include this in your discussion. Remember, you're building rapport by doing so. So when can some third party get my records if I talk to you? Well, if the third party can articulate a darn good reason why they might need your records for their litigation, then a judge might approve it. But the rule of law in general is, if somebody else wants to get your patient's records, they've got to have a very good reason in court. Examples of places where that's been upheld are where a person is on trial for murder and they assert that a third party's mental health records contain information that will tend to clear them of charges of murder. And even under that kind of dire circumstance, courts tend to put some restrictions on how they can get a hold of records. But be sure to tell your patients, if they sue somebody and make their mental health a legal issue, they've just opened the floodgates for opposing counsel to get every mental health record on them going back to birth, if not before. So if you put your mental health at issue in a case, such as by saying, I've had PTSD because of this auto accident, okay, the other side is now entitled to find out every mental health visit you've ever made. So be careful about that. You open the door. What if somebody's just nosy and wants to get their hands on your mental health records? Typically, judges get really ferocious with people who are just trolling around for information. Judges are not monsters and they're not klutzes. They understand how important privacy is to mental health patients. And if they get even a whiff that somebody's just trying to troll around, well, read some case law. You'll find cases where a judge shows just how much they don't like that. So talk that over with your patients during the informed consent process. Now, it's important to understand that a subpoena is not the same as a court order. A judge is a member of the government. An attorney works for the government, but is not a member of it. If a court orders you to do something, you can never be held liable for complying with a court order. A subpoena is not a court order. Now, in some jurisdictions, such as Illinois, if an attorney sends out a subpoena for mental health records without a court order attached to it to release those records, that attorney has just committed malpractice. So this is another reason it's important to get familiar with your jurisdiction's laws. Now, if you work in an agency or institution like a VA or a hospital system or a prison, and you get a subpoena that requests records, send that request to your records officer. Part of the point of being in a large organization is that you have a records management officer, and that's the person who stays up to date on how to handle these kinds of requests. Give it to them and wait to hear. Usually a good idea to tell your supervisor too. If the subpoena orders you to show up in court, show up in court. When you're put on the stand, assert the privilege from the witness stand and then do whatever the court orders you to do. And again, the way you do that is you say, when the first question is put to you, you turn to the bench and you say, at this point, I'm going to assert the privilege on behalf of the person who is the subject of the records. Here is the most recent article from the APA's Committee on Legal Issues covering strategies for private practitioners who are coping with subpoenas or compelled testimony. This will eventually get another update, but this is the most recent version. So let's assume that you're in your own private practice and you get a subpoena. Okay, let's sketch out the steps that I suggest people follow, which are a form of what's in that article. First off, if you have a physical file and you get a subpoena for records and you are your own records custodian, take the physical file into your custody. Make any copies yourself. Don't give this to one of your staff people. This is an important issue. You want to control it yourself. So I was in a private practice and my two partners and I were seeing all of the members of a family for different purposes. And then we got a request from the county attorney for all of our records on everybody as part of a termination of parental rights action. So we went through our files and put tabs on the pages that would comply with the subpoena, then handed them to our front office person to copy off in between other tasks. So I went into a session at 1 o'clock and came out at 1:50 and went into the office and said, "How's the copying coming along?" And the front office person said, "Oh, the records have been delivered." And I said, "What do you mean delivered? Have we heard from the attorney about the motion to quash?" So the front office person said, "Well, I finished copying, but there were 300 pages, and that was too much to fit into our fax machine. So I called the county attorney and said, 'I have too much to fax. How would you want these delivered?' And he said, 'Oh, I'll send a deputy right over.' And in about a second and a half, like the roadrunner, just brrr, there's a deputy at our door holding out his hand, and she gave him the records. Now, as it turned out, we were legally in the clear because there is no privilege in Iowa in a parental fitness or termination of parental rights action. But we were just sick about that. Okay, so that's where I say if you get a subpoena and you're your own records custodian, grab that file, and if there's any copying to do, you do it. You be the one to fax the records. You be the one to mail them. Don't entrust that to anyone else because it's your responsibility to protect those records. Physical files. So take physical files into your custody. The next thing to do is contact the patient. Ask if they want the records released. If they're okay with having it released, have them sign a release of information to disclose the records and you're covered. You just send them out. Otherwise, if they do not want their records released, subpoenas have to give you sufficient time to comply, which is usually 14 days. So run the subpoena past your attorney and ask your attorney to file a motion to quash or a motion to limit access to the records with the court where the subpoena was issued. If the subpoena remains in effect when the time expires, comply with it. If you're subpoenaed to go to court with your records in the order that you keep them when doing business. There have been some people who got snippy about being subpoenaed and they scrambled their files. Don't do that. Courts really hate it when people do passive-aggressive stuff like that, and they will come down on you hard. And then again, when you take the witness stand, assert the privilege on behalf of your patient. Now, I mentioned up there, run the subpoena by your attorney. And I hear you saying, why do I have to have an attorney? I don't want to have an attorney. Attorneys cost real money, and it's really intrusive, and I'm not comfortable with it, and all that kind of stuff like that. I want you to listen to yourself when you're thinking that and realize that every reason you have for not having an attorney is a reason that your patients have for not seeking psychotherapy. What would you tell them to do? You'd tell them to get the help you need. The place to scrimp and save on your practice expenses is not your lawyer. Get the best one that you can find. Attorneys are often fine with looking something over and advising you for free. They only start billing if it adds up to a real action. So get yourself a lawyer, get a good relationship going, and your life is going to be a whole lot better. Now, one topic that comes up from time to time is the request for psychological test materials. Attorneys can and will subpoena you to get a copy of the exact raw data test protocol, particularly if you're doing neuropsychology. Again, jurisdictions differ as to how this is handled. My favorite license is my Iowa license because under Iowa Law 228.9, psychological test materials can only be released to another psychologist. They cannot be released to the patient or to an attorney or to any member of the executive, legislative, or judicial branches. They can only be disclosed to another psychologist. So I really like that license. States have different laws as to how to protect our tests from getting copied off and circulated around, and unscrupulous attorneys coaching their clients on how to fake on our tests. Okay. Remember that you can never be held liable by a third party for obeying a court's order. So if you're using the MMPI-3 or something like that, and a court orders you to hand over your test booklet to opposing counsel, do it. And then if Pearson tries to sue you, that suit is going to get thrown right out of court, because no court will ever punish you for having obeyed another court's direct order. The grounds on which we resist these kinds of requests when we don't have a law like Iowa's law. Contract law. We sign a contract when we buy a psychological test, saying that we're going to protect the privacy of this test in order to preserve its integrity and its usefulness in the future. We have to comply with that contract. Copyright law. Every test has a copyright statement on it, on the first page, and in some cases on every single page, saying no reproduction of this page is permitted without the permission of the copyright holder. Now again, I don't stand above copyright law. In fact, copyright law is federal. So if this is a state court action, how are you supposed to order me to break a federal law to comply with the state? That's a ground on which we argue. And trade secret law. Trade secrets are recognized at multiple levels of the law as a form of property right. Having a trade secret creates some of the value of a test, which a company like Pearson sells. So if we violate the trade secret in order to comply with some attorney's subpoena, we're diluting a third party's property rights. So these are grounds on which we will try to resist requests for raw materials. If someone is asking for a copy of your book or your manual, then what you tell the court is, that's the tools of my trade. That's like telling a carpenter, you got to hand your toolkit to this lawyer who's going to keep it for several weeks. How am I supposed to do my job? That's my actual tool of the trade, Your Honor. And judges typically understand that. If you're caught in one of these things, apart from having your own lawyer and having your lawyer research this before the day you get the subpoena, whether we're asserting a privilege or trying to protect our tests, courts will take requests more seriously if we offer them an alternative rather than a flat no. And the most common alternative we offer is, I don't want to release a raw data protocol to some attorney. I will happily release it to another psychologist who's employed by that attorney. And then that psychologist is bound by whatever rules of the road apply to that psychologist. But that way, I'm not handing a bunch of tests to an untrained, unqualified, and potentially unscrupulous person who will dilute their value in the marketplace. So that's enough on dealing with subpoenas and requests for testimony. The other time we may be interacting with the legal system is if we get into managing treatment that's mandated by third parties. That can be treatment following a DUI or as an alternative to criminal proceedings, or it can be treatment that's part of the workers' compensation system. Third-party treatment can be mandated by a lot of people. A court can order it, a government agency can order it, an employer can order that somebody take part in anger management as an alternative to getting fired. The thing to understand is that many people in the legal system, because of the way that system works, will try to turn us into cops, because that's the way they think. This inevitably creates ethical conflicts because treatment is always a helping relationship. It is not a form of espionage. It is not a form of judgment. It's a helping relationship. But third parties will sometimes try to distort that because of the way they think. So, for example, I had a guy come to me saying that he was presenting for substance abuse treatment. So I said, "What substances do you use?" And he said, "I don't use any." So I said, "Well, why the hell are you here?" And he said, "Well, I have to be here." Says who? "Well, my employer." Okay, so it took a while to tease the story out of him. This is what had happened 2.5 years earlier. He got a random drug test at his employer, and he tested positive for cocaine. So under their zero tolerance policy, they fired him. It was a union shop, so he went to the union, and it turned out that the drug test had been botched. It had been handled incorrectly. So it was litigated back and forth, and finally it went to arbitration. And the arbitration agreement, which was written in Ohio, by the way, said that he would be allowed to resume work at the company, but he had to do 1 year of substance abuse treatment. So that's what he came to me for. Now you ponder that, and you think about what's wrong with this picture. These are the kinds of things that are going to show up in your office from time to time if you're in private practice. So I sent the guy away, and I thought about it for a while, and then wrote a letter to the Employee Assistance Program that put this together. And my first point was that diagnosis and choice of treatment is done by someone who has an appropriate license and who has a helping relationship with the patient. I was wondering, so could this arbiter have said, you can have your job back, but you have to have your appendix removed or get a nose job? If a surgeon got an order to take this guy's appendix out as a condition of resuming employment, would a surgeon comply with that? No, and nobody would even think of ordering that, but they think we can be deputized as cops. Now, when you see orders from judges, like a guy has a DUI conviction and he's ordered into treatment, the judge's order is typically going to say, we order you to go to this facility, take part in a substance abuse evaluation, and then comply with any treatment that's recommended. Judges don't issue a diagnosis or prescribe a form of treatment. They refer to a person with an appropriate license who will have a helping relationship with the patient, and then they stay out of it. Judges typically understand, but not every attorney really gets that. Third parties who mandate treatment are often entitled to know a certain amount of information, such as, did the person attend? Did the person comply? Did the person complete successfully? Unless the patient consents to more than that, the referral source is not entitled to control or monitor details of treatment. This is in fact the reason that so many companies now have employee assistance programs. They serve as a cutout. So when I've had people sent to me from an EAP for anger management, I will give the employee assistance program many more details about what I'm doing, like, is there a particular program I'm working? Which session are we on? In this particular homework, did the person complete it or did they not? I don't tell them what they wrote, but I tell them more details about the steps. And then, so they are validating that I'm doing good care. And then the EAP reports back to the employer attendance, compliance, and successful completion. That's the right way to do this. If the patient consents to more disclosure to their employer or to their referral source because they're threatened with jail time or termination if they don't, such consent is not valid. Informed consent must be free and uncoerced, or we have no treatment contract. If your patients are in treatment at the instigation of an employer, a court, or a government agency, your first job is clarify the roles and relationships. What am I doing for this person? Who am I reporting to? What are they entitled to know? What are they not entitled to know? Is there a contract in place? Blah, blah, blah. Make sure all that stuff is cleared up ahead of time. And if you are uncomfortable with the conditions, decline the case. You cannot be forced to enter into a treatment contract any more than your patients can. Your consent to provide the treatment has to be free and uncoerced too. The last part of our show is forensic psychology proper. Forensic psychology, a forensic evaluation, is when you use psychological science to address questions that arise from law rather than questions that arise from medicine. So you can always ask yourself the question, do I have to go beyond medical and psychological books in order to know what my job is here? If you have to look up a definition in law, or you have to look at an employment report, or you have to do anything like that, then you've crossed the line into the forensic domain, and you don't want to do that without a lot of preparation. Most clinical measures have no known relationship to legally defined issues. Courts are not interested in hearing us expound in court on our clinical lore. They want us to address the legal question. Failure to do so can create liability. Clinical training is a necessary prerequisite to doing forensic psychology, but it is not sufficient preparation for entering into the forensic arena. So I want to illustrate where the line is here by walking up on it. Forensic psychology has its own standard of care, and whenever you do forensic work, our rules are we will apply the forensic standard of care regardless of whether we call ourselves forensic psychologists. So, for example, the Social Security disability examination. If you ever go into private practice, this is a piece of work that you're likely to pick up at some point. A lot of private practitioners do these. This is not really a forensic evaluation. Why not? Well, the answer is the state sends you a case, a person, they send you whatever records they want to send you. You then do a clinical exam and report back on the person's clinical condition, and you're out of it. The examiner in the state capital who gets your report will make the decision as to whether this person does or does not qualify for disability. You don't make that decision, and that's the forensic question. If you're going to be asked to apply a legal standard to what you find out, you're now in the forensic domain. In the case of Social Security, you don't do that. Typically, they ask you to include behavioral observations rather than your own opinions, because your observations are what the examiner at the state capital is going to use to determine whether the person does or does not meet the standard of disability. You'll probably have to offer a judgment as to things the employee reasonably can or cannot do based on your clinical findings. So from when I did 1,000 of these in Iowa, you'll be asked, can they carry out instructions under ordinary conditions? Can they remember locations and procedures? Can they maintain attention, concentration, and pace? Can they get along well with supervisors, peers, and the general public? And is the person likely to decompensate to stress? So let's imagine someone is coming to me for severe depression. And I've evaluated them, and they look depressed to me, and their symptom reports check out, and it matches what's in the records I got. Can they carry out instructions under ordinary conditions? Well, yeah, there's nothing about their depression that's in the way of that. Can they remember locations and procedures? There's no signs of memory impairment. Can they maintain attention, concentration, and pace? Based on the level of depression I'm seeing, there's questions about this. They may be able to maintain attention, concentration, and pace for short intervals but 8-hour days, 40-hour work weeks, they're probably going to struggle. Can they get along well with supervisors, peers, and the general public? Well, based on what I'm seeing, the only possible problem here is that they might be kind of withdrawn and apathetic. Beyond that, they're not going to be throwing hammers or causing problems. Is the person likely to decompensate to stress? Based on what I'm seeing, probably they would just not show up. And stress could provoke them to not show up. There, I'm done. I send those opinions off to the examiner. It's based on clinical observations, not on legal criteria. I'm safely in the clinical realm. I have not crossed over into the forensic realm. Each of those will be anchored on clinical issues you observe during your exam. It's not guesswork. Okay. Workers' compensation gets you closer to the line between clinical and forensic psychology. So it depends on what you're asked to do. If someone is referred for treatment of PTSD that they acquired on the job, you're being asked to do clinical work, just treat. So a patient came to me having twice been held up while being a third shift cashier at a convenience store. And after the second one, this person was having PTSD on the job. Okay, treat for the PTSD. All I'm doing is clinical work. Before you take the case, it's a good idea to review your state's workers' compensation laws, particularly those that relate to confidentiality. When the workers' compensation system is sending someone to you for treatment, they may mandate that they have greater access to your records than other third-party referral sources mandate. So include this in your informed consent. If you don't want to do this work, then don't take workers' comp cases. But if you are asked to offer an opinion that the patient is able to return to work, don't do it. That's a forensic question. Why? Because whether this person has completed a treatment program is a medical question. It's determined by giving them psychological tests and observing their reactions during treatment. But whether this person can do that specific job goes beyond a medical issue. And employment law is an area of law that's complex and it can be really harsh. So you don't want to be offering opinions about either fitness for duty or suitability for employment until after you've learned how to render such judgments legally safely. So for example, a railroad engineer came to me from his railroad after he was involved in driving a train that hit and killed somebody at a crossing. And he was very obviously having PTSD symptoms. So, for example, I assessed him by taking him out to a rail yard, and we heard an engine running, and I could see the blood drain from his face, and I could hear his mouth go dry. Okay, this guy has PTSD reactions. Okay, so he comes to me, let's write up the incident, let's do cognitive processing therapy on it, let's examine what are some of his stuck points, let's get through those, and we're done with treatment and he feels a lot better. Can I clear him to get into an engine again? No way can I say that he's safe to go into an engine. That is much more detailed of an examination than just doing clinical work and saying he's done with treatment, therefore he can go back to the job. I don't know what circumstance he might encounter in the future that will cause a sudden return of PTSD symptoms. And I don't want to find this out by having the symptoms suddenly reappear while he's driving a 150-car train. Okay, that's a separate question from did he complete treatment? So that question, if you are asked to treat somebody and then clear them to return to work, advise the referral source that the return to work decision needs to be examined by someone other than the treating clinician. That's how you handle that. Okay, crossing the line into forensic psychology, fitness for duty. Fitness for duty and suitability for a job are forensic questions because courts and legislatures have long since ruled that people have a substantial property interest in holding a job. And because of this, there is an extensive body of employment law that specifies when are employers allowed to ask psychological questions before extending someone a job? What are the criteria that are allowed and what are not allowed when you're bringing someone onto a job or you've taken them off for cause and you're deciding whether they can return? There is a large body of employment law, and if you're offering an opinion as to someone's suitability either to get a job or to come back to a job, all of that law falls upon you and you have to comply with it. If you're doing this as a work done for hire for some government agency like a police force, you also fall under Section 1983 Civil Rights Law, and you can be sued for violating that as a government agent. Even if you don't work for the government, you contract it out to them, you're now a government actor and you can be sued for civil rights violations. Will your malpractice policy cover a civil rights violation? I don't know. Read your policy. Try not to become a test case. My goal is to retire without once being a test case in some court. This article from 1997 is still referenced in forensic psychology. This is where two board-certified experts wrote up all of the reasons that therapeutic and forensic roles are irreconcilably different. If you are a treating person, you cannot offer legally relevant opinions. If you're in a forensic role to somebody, you cannot also treat them. This is now dogma in the field of forensic psychology. And in some states, this has been encoded into the law. You can't blend clinical and forensic roles. You can easily get sucked into offering a forensic opinion without realizing it. So, can you sign this letter saying I'm unfit to work? Or can you sign this letter saying I'm incapable of paying back my student loans? Okay. In order to do that, you'd have to look up the legal standard for unable to pay back student loans, right? The moment you have to look up a law, you're in the forensic arena. That's not clinical work. Or could you tell us if our employee is ready to come back to work? Okay, that's a fitness for duty evaluation. I represent your patient. Can you tell me if the person's mental illness was caused by this accident or this crime victimization or what have you? Okay, when you're trying to trace cause to a legally relevant issue, you're going to be offering a forensic opinion. Or I represent your patient. Was he sane at the time he allegedly committed this assault? When you offer answers to these kinds of questions, you are taking on legal liability for being wrong or for falling below the standard of care of forensic psychology. So don't cross over into forensic work until you've had extensive preparation in forensic psychology. So let's talk about areas of full-blown forensic practice to forewarn you. Competency is almost always a forensic issue. So by that I mean competency to make a will, competency to manage your own financial affairs. The only competency issue that comes outside the domain of forensic psychology is, are you competent to consent to treatment? And that's something each of us has to evaluate every time we form a treatment contract with somebody. So that can't be considered a strictly forensic issue. If the case is a close call, you may want to actually refer to a different examiner. Otherwise, competency to stand trial, things like that, forget it. That's forensic work. Criminal responsibility. Were you insane at the time of the offense? Risk of committing future violence, strictly a forensic question. Disability status. If you're the one saying, does this person fall above or below the legal definition of disability, then you're offering a forensic opinion. If you're doing a clinical examination and saying what you saw, that's not a forensic opinion. Eligibility for a specific program. If criteria for entering into this program are established in law and you have to look up the law, consider that forensic practice. Psychological damages. So I was a crime victim, I was in an accident, something happened to me, I'm suing somebody, and I want you to determine, are my psychological symptoms the result of that? Forensic work. Child custody, parental fitness, termination of parental rights. Not only is this forensic work, only specialists in forensics will touch these cases because there is a high risk of board complaints and lawsuits. Death penalty litigation. Okay, these are some of the areas that are over the line into the forensic domain. My advice is don't go into this stuff without extensive preparation. You can get preparation from the American Academy of Forensic Psychology. They offer workshops 5 or 6 times a year in various places around the country, and they do very good training. Among other things, if the American Academy of Forensic Psychology offers a workshop in suicide risk, go take that thing because you will get stunningly good education on how to evaluate for suicide risk. The legal basis for offering an opinion in legal questions will be found in the state or federal rules of evidence. So the rules of evidence state when you can testify as an expert in the form of an opinion. Testimony that does not conform to that legal basis can and will be excluded from court. Expert witnesses are permitted to testify in the form of an opinion. All others can only testify to the facts of what happened. Now, there is a tricky situation. You may be called into court as what's called a treating expert. That means that people understand that you will be offering clinical opinion testimony. In my opinion, this guy has PTSD. That's a clinical question. But some attorneys may try to tempt you into crossing the line into offering a legally relevant opinion. So if you're called on to testify and you're going to go into court, you do want to clarify, are you calling me as a forensic expert or are you calling me as a clinical expert? And if you're a clinical expert, you can testify to opinions that you formed during the course of giving treatment. Nobody can force you to form a new opinion because it would be nice for them if you would do that right now on the witness stand. No way. You just testify to the opinions you formed about the person's clinical status during treatment. And everything else you say, I don't know, I don't have a basis for that. So an example of how I would handle the difference, I mentioned earlier seeing someone who had PTSD from being robbed twice while on the job. Let's imagine I was called in to testify about that at a case for, I don't know, liability for something. She's suing somebody. So the attorneys ask me, did this person seem to have PTSD? Yeah. How could you tell? Well, I gave this checklist. I observed these signs and symptoms. I went through this treatment. I observed this response. Looks like PTSD to me clinically. That's fine to say. That's all clinical opinions. Now let's imagine the attorney says to me, so do you believe that the PTSD was caused by the actions of the defendant sitting over there looking guilty as hell? My answer would be, I don't know. I only saw this person in the clinic for a complaint of PTSD, which I treated. I didn't review the person's whole life history to determine, did they go through maybe domestic violence that contributed to their PTSD. I didn't check on things like that. I didn't examine, does this person have an undiagnosed substance abuse disorder. I didn't do all of the rule outs that a court would care about, but that are not relevant to clinical care. So I can tell you what I saw, what I did, and how it worked. The rest of this is for counsel to argue to the trier of fact, not for me to offer an opinion on. Have at it, duke it out, guys. I wouldn't say that on the stand, but you get the idea. The federal and most state rules only permit opinion testimony from a person who is qualified as an expert. That means your credentials will be elicited from you under testimony, and the court will then rule as to whether you will be allowed to testify as an expert. And even then, your testimony can only be allowed if it's helpful to the person who's going to make the ultimate decision, who is called the trier of fact. If you decide you want to get into some area of forensic practice, here are some resources that you'll probably want to look at. That's still 4th edition, and that's the current 2nd edition. That's a nice book. And the American Psychology Law Society sponsors a series of small paperbacks on single-issue forensic topics. They're usually pretty good books. Why would you ever want to get into this? Well, there are many good reasons for not doing so. It is a lot of extra work. Not only do you need to read psychological literature, you really do need to familiarize yourself with the law in the specific area before you go offering testimony and doing evaluations. One of the benefits of doing forensic psychology is it puts your work into a critical arena where you will find out just how solid your practice is. So I have seen in myself, and others have commented to me, that as they started doing forensic practice, they found out quickly where their methods were solid and where their methods were actually a little weak and they needed to raise their game, or else pull back on what opinions they were willing to offer. So doing forensic cases is a way to really sharpen your thinking, and you become a better clinician in the end, even if you don't end up doing a lot of forensic practice. So that concludes this presentation. My hope is that this does something to put your mind at ease, but more, it shows you the directions in which you can educate yourself to put your mind more and more at ease as time passes. Do your own legal reading. Do get an attorney, get familiar with where the lines are, withdraw your projections onto the legal system, and you will sleep better and you will do better care for your patients. Thank you.